Good afternoon, folks. We have 3 hours of requested argument time, and I would ask, on behalf of my colleagues, that you ask for the time you need to convince us of your most important positions and not the time you need to educate us about your case. We are a hot bench. People versus Walter Jones. Okay, 4, 1, and 4. Palomino versus City of New York. 5, 2, and 4. The next case, Rivas versus Fred Smith Plumbing. Just 1 second. Justice Shulman is recused, and Judge Scarpula will be vouched in. This case will be heard first. So, appellant?
Sure. Plaintiff appellant 4 and 2, please. Respondent 4.
4, 2, and 4. 47 East 34th Street versus Bridge Street Worldwide.
Good afternoon, Your Honor. Appellant first requests 8 and 2. Appellant Thomas Grundy requests 8 and 2.
Respondent 47 East, request 13 and 2.
So, well, you have a cross appeal? Okay, so I'll give 8 and 2, 8 and 2, and 10 to the respondent. People versus Terrace Pugh. Submitted. Rockmore Contracting versus the City of New York. Colleagues? Questions? Submitted. People versus Jonathan Batista. Submitted. Surefire Dividend versus Industrial and Commercial Bank. 5, 2, and 5. And the last case, the Gould matter, is submitted. So the first case on the calendar is Rivas versus Fred Smith Plumbing. You may proceed, counsel.
Good afternoon. May it please the court, Michael Cassell, Hogan and Cassell for the plaintiff appellant William Rivas. In this matter, as we set forth in our briefs, Mr. Rivas was severely injured when the earthen walls of the excavation that he was working in collapsed upon Mr. Rivas, burying him alive, essentially. The Supreme Court, as we cited in our papers, essentially relied upon decades-old cases.
Well, what about those cases? In light of more recent Court of Appeals cases, what's the view of the plaintiff?
The view of the plaintiff is,
Go ahead.
The view of the plaintiff is very simply is they shouldn't be followed. We cite Kwiatkowski, we cite Walensky, we cite Runner. Those cases, for the most part, deal with the issue that stems from Miseretti case, which is when the base of the wall is at the same level as the plaintiff, the labor law is not implicated. That's clearly no longer the law. In fact, I would argue that, this plaintiff was put in a situation, I would argue, way worse than even a regular wall. Because if a wall collapses and you're inside, there might be some room to run. My client is in a situation where he has 6.5 to 12 feet earthen.
Counsel, he was 5 feet 5 inches tall, is that right?
And he's bending over.
He was kneeling at the time, correct?
I'm sorry?
He was kneeling at the time, correct?
Correct, yes, Your Honor.
Now, Mr. Stasi said the depth was 8 feet. Does that matter?
I submit it doesn't matter. We do have testimony that goes from 6.5 feet up to 12 feet. The height of the wall was clearly over his head. The prior cases relied upon by the Supreme Court deal with this situation, certainly pre-Walensky, where the base of the wall, there would not be a labor law violation. That's not the law. My client is buried alive. And just, one more important point, Your Honor. It's clear defendants knew that this object, the wall, required securing for purposes of the undertaking, because if you believe defendant's story, they had shoring there. Shoring was supposed to be there, undisputed, at least we submit there's no shoring, but even if there was, the shoring failed, the wall collapsed, that's a 240 violation. We're entitled to summary judgment. Any questions? Thank you.
May it please the court. Joel Simon from Smith Major for the respondents. Counsel's argument is simply that due to the Court of Appeals decision in Walensky, the law has been modified so that it now applies to trench wall collapses. Respectfully, Walensky only dealt with the issue of where the object which collapses is on the same level as the construction worker. It doesn't deal where there are other grounds or other bases.
Wait a second, but isn't it worse if the object comes from 8 feet or 5 feet above? Are you saying that this situation makes it less?
No, Your Honor, I'm not saying
subject?
that.
What
What
are
I'm
you
saying,
saying?
Your Honor, is that there are other reasons, other rationale why 240 may not apply to certain situations. This is one of them. Ms. Arati and Walensky discussed that a brace, as defined by the labor law, is not the type of brace that supports in a trench situation. It's meant to, the brace in the labor law is meant to be applied where you're dealing with a elevated structure. Walensky references
But this, counsel, isn't this in effect an elevated structure because the plaintiff is maybe 9 feet down below, working where there is apparently shoring, and wasn't it the effect of gravity that brought about the collapse? So how is this any different than a case like Walensky where it happened on ground?
Your Honor, Maserati, and as Walensky references Maserati, talks about situations where the type of brace, and this is allegedly a failure to brace case in a trench, where it does not reference shoring. A brace is under the labor law, under the enumerated type of device in the labor law, a brace does not equal shoring.
Is that exclusive? The enumerated devices?
Pursuant to Maserati and as cited in Walensky, it references that
No, but it could be, there
Walensky
could be
states-
10 other.
It could depends. Everything is factual. Your Honor.
Exactly, right?
But in this situation, what the allegation is that it was not shored properly. Walensky says, hey, Maserati was different because Maserati dealt with a brace/shoring issue. That's not what we have here in Walensky. Our situation, and Walensky, to the extent that counsel references it, goes solely to that height differential issue. But there
I'm
are
really
other
curious,
reasons.
why is that the linchpin that makes you not liable under 241?
But part of the reason, Your Honor, is that a bracing/shoring, as we're discussing here, is integral to the work. It is not a device used to support a building or support a structure.
Did
of
you
that
raise
type.
the integral defense below?
It was raised in the sense only, Your Honor, that we were saying Walensky does not apply.
I don't remember the word. Did you ever use
No,
the word
we did not
integral?
use that
Because-
terminology. We
thank
did
you.
not use that terminology.
But ultimately, isn't the question whether the plaintiff was exposed to an elevation-related risk? And if the answer to that is yes,
Not completely, Your Honor, because as noted by numerous cases, every elevation-related risk does not get the benefit of 240. There are situations, there are scenarios where it's not an enumerated device, where it's integral to the work, and so on, where simply because it's elevated does not mean you get 240. And this, frankly, is one of the cases, not a single case cited by counsel, deal with a trench wall collapse. Not a single case.
do you agree that all of the cases that are on point that you've identified are pre-Walensky?
Except for Walensky itself, which references Maserati, which discusses the brace issue, Your Honor. Thank you.
Thank you.
And Amato, I'm sorry, and Amato, which also discussed the brace issue.
Oh, your notes are here.
Go ahead, counsel.
I'll just be very quick, obviously, in rebuttal. I mean, first, we cited the multitude of cases. I don't think even defendants dispute that 240 applies to walls, wall collapsing. This is an earthen wall. For whatever reason, the earthen wall collapsed on my client.
But counsel, what do you say to his argument that none of the enumerated safety devices in the statute apply here?
Well,
Yes, that's his argument.
I disagree completely. We have a falling object case. It's undisputed that in a falling object case, it's hoisted, secured, or hoisted or should be secured for purposes of the undertaking. That's the key.
So it's not just, a brace is not the only thing that could have been used to support these walls?
I don't care. Anything should have been used to prevent a situation where an avalanche of dirt falls on my client. That's a gravity-related risk that he was not protected against. He's entitled to summary judgment. Thank you, Your Honor.
Isn't there a body of law that indicates that in defining or identifying when a worker is exposed to an elevation-related risk within the meaning of 240, we look to the devices that are enumerated to see if they were within the intention of the legislature to be covered?
There are devices at issue. I mean, for example, if the plaintiff is using an elevation-related device, such as a ladder or a scaffold, but the law also says that in a situation where you have a falling object, not a falling worker, so it's not a situation where we're trying to see is the worker using an enumerated elevation-related device, with a falling object, if the object is not properly secured, which it clearly wasn't, that's a
So your hook is it's improper. It wasn't properly secured, and that's what brings it within 240. Is that correct?
Correct, Your Honor.
Thank you. Okay, first case, People versus Walter Jones. You may begin, counsel.
Thank you. Good afternoon, Your Honors. May it please the court. My name is Nicole Gioglis, and I represent appellant Walter Jones. Walter Jones has been registered as a high-risk Level 3 sex offender registrant for nearly 22 years. During the last 2 decades, the majority of which he spent in the community without supervision, he's complied with his registration obligations, and he's not once sexually offended.
So what are the mitigating factors you say weigh in his favor versus obviously the factors that don't? And how do they outweigh the other factors?
The central mitigating factors in this case are primarily what I just mentioned, that he's been in the community for 2 decades with no contact with the criminal legal system, no rearrest for a sex offense, no arrest for any offense. He has been sober for 27 years. He successfully completed parole in 2008, and that included successfully completing an outpatient sex offender treatment program.
Is he in full compliance with the SORA requirements?
Yes, for 22 years, he has reported in person every 90 days as required as a Level 3. He is 71 years old. At the time of the petition, he was 69. The offense itself is 35 years old. It's his only contact.
Counsel, you do a very good job marshaling all these facts, but one thing that concerns me is, has he ever shown an admission of guilt?
He successfully completed sex offender treatment, and there's no evidence that he's denied responsibility since he began and enrolled in sex
Well,
offender.
I think what we're asking is about remorse. Has he shown remorse? Or how has he shown remorse?
By completing sex offender treatment and participating in the treatment, and by taking it seriously, by complying with all of his obligations, and by not reoffending, he has shown that the conduct for which he was convicted was clearly an aberration. It's his only criminal contact. To say that he remains a high risk to the community is nonsensical after the amount of good behavior that he's shown.
But you're asking also for a reduction from level 3 to level 1. You know, maybe there's an intermediate ground. What's your view of a level 2?
We do believe that there's clear and convincing evidence for a level 1, but there certainly is for level 2. In fact, the Board of Examiners recommended, didn't even just say we don't oppose a reduction, but recommended a reduction to level 2, which is quite significant. Both of those were opposed by the prosecution and denied by the Sora court.
So this is governed by Galati, correct?
No, Your Honor. This is a 168-0 modification petition, in which case the downward departure analysis in Gelati does not apply.
Okay, and ultimately, though, like Galati, it would be a discretionary determination for the court.
Yes, Your Honor.
Okay, and what rationale did the trial court give for denying you a downward departure?
The trial court did not give any rationale, simply found that there was not clear and convincing evidence in support of any modification and maintained the existing level. The trial judge did not expound on that issue at all. We do submit that there is clear and convincing evidence supporting a level 1, given the amount of time that Mr. Jones has spent in the community in compliance with his obligations and with good behavior, his sobriety, his support system, and his advancing age. To the extent that the court is not inclined to reduce his level by 2 levels, certainly there is sufficient evidence.
So what are the differences between, say, if we were to agree to reduce him from level 3 to level 2, what are the different reporting requirements between 3 and 2?
So as a level 2 registrant, Mr. Jones's information would still be on the internet, but the main difference for him would be that he would not have to travel to 100 Center Street and verify in person that he was still living at the same address he's been living in for 2 decades. He would still have to complete an annual verification form. He'd still be subject to a felony conviction were he to move and not notify law enforcement. And I'm sorry, there's one other difference. He would appear for a picture once every 3 years as opposed to annually.
Thank you, counsel.
Good afternoon, Your Honors. May it please the Court. Elliot Hamilton for the people of the state of New York. Your Honors, as you pointed out, the burden of proof is on the defendant to show by clear and convincing evidence that he warrants a modification from his current
So he's
status.
71 years old, has lived a crime-free life for over 20 years, right? He's complied with the SORA requirements, negative for drugs. The SORA board is in favor at least to a level 2. Why shouldn't we reduce it to a level 2?
Your Honor, the only thing that the defendant showed by clear and convincing evidence from his petition and during the hearing was that he has stayed out of trouble. Everything else that the defendant brought forth,
He's not 71 years old?
other than his age is not
Has he
necessarily.
complied with the SORA requirements?
Your Honor, he did comply with so far he has complied with the SORA requirements.
And how long has he been complying with the SORA requirements? For how many years?
For about, except for the instance in which he violated his parole by being in the presence of one of the victims that he molested and had to be incarcerated for a year, he has, for the most part, been in compliance with all of it. But the elephant in the room, Your Honors, is that the defendant still has not affirmatively taken responsibility for his conduct. And the
What about
conduct,
what your adversary argues by completing various programs, that shows sufficient remorse?
Your Honor, the defendant only engaged in sex offender treatment after he was released on his parole violation and then allegedly engaged in it for 3 years, and there is no evidence and no proof that he indeed completed that programming. For all the things that the defendant brought forth in his petition for the modification, there was no evidence to suggest that he completed the programming. There was also no evidence to suggest that he had the medical conditions that he alleges prevents him from reoffending. But it's also, and more importantly, he failed to show by clearing and convincing evidence that that the medical conditions that he currently has will prevent him from reoffense. And this is also important because the defendant in this instant crime coerced his nephew, his teenage nephew.
There's no dispute here. What was done was heinous, but years have gone by. So the question is should we exercise our discretion to reduce it maybe by a level?
Your Honor, as the people in the court determined that based on the fact that the defendant still has not affirmatively taken responsibility for his egregious conduct, that the only things he was able to provide by clear and convincing evidence was that he did comply with the SORA requirements and that he did not get arrested, minus the one parole revocation, that he did not show by clear and convincing evidence to the court that he indeed deserves a modification of him, And we submit to your Honor that the facts of this case, substantially outweigh the everything else that the defendant does show as mitigation, including the factors that he failed to show by clear and convincing evidence.
And what should we make, counsel? What should we make of the SORA board recommending a level 2 reduction or modification?
The court can consider the board's recommendation, but it does not necessarily have to adopt the
Well, how much
findings.
weight, if any, should we give to it?
I believe that the weight that even the SORA board acknowledged that the fact that he fails to affirmatively acknowledge his conduct and has not shown remorse for his egregious conduct
But didn't the
is
board,
still significant.
Would you tell me if I'm mistaken, but didn't the board also say that further modification wasn't warranted for the reasons you're saying? So in other words, not a level 1, but a level 2.
That is true, but the court had its discretion to take it all into consideration, and based on the totality of the circumstances brought forth by defendant's petition, which, as we submit, does not show by clear and convincing evidence of anything else all the mitigating factors that if the defendant wishes to repetition the court for it, maybe next time the defendant should provide additional proof that suggests that his medical conditions will prevent him from reoffending and that he is indeed remorseful for the egregious conduct that resulted in him being a level 3 sex offender in the first place.
Sir, I heard you mention the word discretion a couple of times, and I asked your friend this question. What was the court's rationale for denying the downward departure?
The court, in this case, Judge Bruce did not provide a written decision or did not provide an oral decision for all of it, but we would submit that based on the testimony, on the arguments that were provided to the court, and as well as the petition and the people's opposition to it, that the court made a determination that the petition should be denied, and for the reasons outlined from there, we believe that the court was correct in doing so.
Thank you, Counselor.
Thank you much.
You may proceed.
I would just like to briefly correct two things with regard to the record. As to whether Mr. Jones provided evidence of his participation and completion of treatment, in Exhibit D to his petition, the last page of the exhibit indicates a parolee programs list. This is a document maintained by the Department of Corrections and Community Supervision, which lists Metropolitan Sex Offender Outpatient Treatment Program from July 7th, 2003 through December 1, 2006. And on page 8 of that exhibit, there's an entry where his parole officer noted that he completed Metropolitan and attends as needed the support group. I'd also note with respect to whether, I'd like to provide some context with respect to the incident that resulted in his parole violation. In that case, while he was violated and did receive another year incarceration, it was not an instance where he affirmatively reached out to the victim. He was living with his parents. The victim, who was a family member, had a relationship with the parents, and had visited the parents at the same time when he was home, whereas normally he would absent himself if the victim was going to appear. He did serve time for that violation, and the remainder of his parole when he was released.
How long ago was that, Counselor?
That occurred in 2001, shortly after he was released. Since 2003, he's been in the community with no issues.
It is my understanding that the sex offender treatment programs are, as other similar types of addiction-type programs, one of the key aspects of those programs is to acknowledge your problem, correct?
Yes, Your Honor.
So
Yes.
basically, without waxing colloquial, but you stand up, say your name, and you pretty much acknowledge that you have a problem.
Yes.
And that perforce suggests that you regret it or you have remorse for that. Wouldn't that
Yes,
be
Your
another way of saying that?
Yes, Your Honor. And I believe this court recognized as much in People versus Solomon that completion of sex offender treatment is some evidence of remorse and acceptance of responsibility.
Thank you, Counselor. Thank you. Next up, Palomino versus the City of New York. You may proceed.
Thank you. May it please the court, my name is Alexander Gilbert. I am from Gilbert Law Group. We represent petitioner appellant Nicholas Palomino. Nicholas Palomino dedicated his life to pursuing his chosen career path as a New York City police officer.
Sir, there's no dispute on this record that he passed his civil service exam and did all the paperwork that was appropriate. We all can agree to that, correct?
Yes.
And as much as he said, I'm qualified and I should have gotten a seat in the academy, and I'm not making light of that, was there anything in the record as part of your petition to suggest that when they selected the 1 out of 3 rule,
Yes.
pick someone in lieu of Mr. Palomino, that they were arbitrary and capricious about what they were doing? Like there was something really negative about the process that would call into question their decision-making, which, as you know from Gomez and the other line of cases, pretty much allow the discretion of the police department to be able to pick their candidates, so to speak.
Yes. The police department does have discretion to select an applicant for employment. However, they do not have unfettered discretion. Their discretion is not unlimited.
So what are the boundaries? What are the boundaries of that discretion?
Well, according to Matter of Fish, when petitioner set out in considerable detail his schooling and his employment history, and it can be said to be of a fairly high order, then the query naturally suggests itself, why an exemplary record?
Are you saying that shifts the burden in some way to the defendant to show that the other candidates had attributes that were superior to Mr. Palomino's?
It doesn't shift the burden, but according to Matter of Fish, if there is an exemplary record such as petitioner had, then the respondents are then there is actually a presumption that there was no valid basis according to Matter of Fish.
But how can we say?
Sorry. Go ahead. I'm sorry. I apologize.
How can we say that without knowing about the qualifications of the other candidates who were chosen?
It's impossible to know of all of the qualifications of other applicants. However,
But also, it seems to me that we essentially throw the 1 in 3 rule out the door. Then it just becomes who's the best qualified. I mean, that's and how are we to decide that?
it's not throwing out the 1 in 3 rule. It's saying that the 1 in 3 rule does not give the respondents unfettered discretion, unlimited discretion. They still have to, for example, for some reason, 2 years into the application process, when Mr. Palomino had gotten nowhere whatsoever with the investigator assigned to his case because the investigator was refusing to respond to emails, communicate with him, set up evaluations, despite all of Mr. Palomino's pleas to do so, a new investigator was assigned to review his application out of nowhere, and she didn't even interview him. So he never even had a fair shot to be considered for appointment. Not only that, but it's clear that, according to the 1 in 3 rule, Mr. Palomino was supposed to be fairly considered on 3 separate occasions, and he was never fairly considered on 3 separate occasions. The earliest that
What's the basis for you saying that, other than that he didn't get the job?
because there was, I guess it was January of 2020, the investigator assigned to review Mr. Palomino's application informed him that his application was not certified complete for review yet. She said that you're not site qualified yet. And then there was no class in March 2020, and there was no class in July 2020. So the earliest that his application could have been reviewed was for the November 2020 class. And so it's clear, based on that alone, that there's no way that his application was fairly considered on 3 separate occasions.
Unless they reviewed the paper application.
According to the 1 in 3 rule, your application cannot be fairly considered until it's certified complete. And so his application was not certified complete until, like I said, at the earliest February 2020, but there was no further recruit classes in that year until November 2020.
Was there any requirement in the law, sir, that he be afforded an interview?
The requirement under the law is that he's fairly considered. Now, he passed all the other, like we discussed already, he passed all the other requirements. He passed the background check, he passed the physical examination, the psychological evaluation, medical evaluation. If there was any valid basis, respondents could have let him know at any point that he was not going to move to the next level because he failed one of these examinations. The respondents never did so. And it's clear that if there was any valid basis, at this point, respondents would have provided that valid basis.
But isn't it the law that even a well-qualified applicant can be denied an appointment?
There has for it to be the arbitrary and capricious standard is if there's no valid basis for him to be denied, then that decision can be overturned, and that's what we're here for. In Article 78 is to review that.
Thank you. You'll get an opportunity to respond.
Good afternoon, Your Honors. May it please the Court, Kevin Osowski on behalf of the respondents. Appellant is asking this Court to appoint him as a police officer and to order back pay back to 2018 based solely on his belief that the only explanation why he was not selected for a police officer candidate position is that his application was not reviewed. But the record doesn't support that. The petition doesn't support that. His petition fails to allege that the city's hiring decision was arbitrary and capricious. I'd just like to make a couple points in response to...
Well, was it? I mean, what's your position? We have the 1 in 3 rule. You've heard the arguments. He wasn't fairly considered. He's well qualified, et cetera.
Sure. So first, with respect to his arguments that Fish is controlling here, Fish is a Supreme Court case that's not binding on this court, as well as a case that goes back to 1964. Pardon?
When was Fish decided?
In 1964. So there's been some developments in the law since then, and including this court's opinion in Gomez that's squarely on point here that talks about how candidates with very good service records can still be passed over without an abuse of discretion by the agency, and that the agency has no obligation to provide reasons for declining to appoint a candidate, and that the failure to explain why a candidate was or was not selected is not evidence of that the decision was arbitrary or capricious. I think I should clarify how the 1 in 3 rule actually applies in the civil service context with respect to selection of police officer candidates, just to sort of to clarify that point for the court. After candidates take the civil service exam, they're ranked according to their score, and under the civil service law, the agency has to fill openings within the new class with one of the top 3 candidates. And that allows the agency to consider factors other than the pure score, all the sort of ineffable things that go into an agency's discretionary determination about who would be a good police officer and who may be ineligible for police service.
Are there bounds to that discretion? I mean, what can't you do?
Pardon, Your Honor?
What are the boundaries for that discretionary authority?
Well, as this court has acknowledged, the bounds for that discretionary authority are rather broad, especially in the context of selecting police officers. Now,
in other words, the decision has to be irrational, something like that.
Correct, and obviously the agency can't can't engage in discriminatory acts as part of its discretionary determination, but the court has acknowledged that there's a broad band of considerations that the court can consider. But with respect to the 1 in 3 rule, as candidates are selected from that group of 3, the group of candidates for consideration moves down the list. And once a candidate has been part of one of those panels for consideration, one of those groups of 3 for 3 times, then they can be removed from consideration from the list entirely. And that's how Palomino was considered as 3 of those separate, on 3 separate occasions, because he was considered as part of those 3 separate groupings for the incoming class of officer candidates. And that officer candidate class was hundreds of people wide. And just on the point of the question of whether or not he was given an interview, his petition doesn't allege that he was denied an interview. It's silent on this question of interview. I think the most that it says is that someone from the NYPD talked to him about that the next step would be scheduling an interview. So I don't think that it's properly before the court to determine that he was improperly denied an interview here. If the court has no further questions, we ask this court to affirm.
Thank you, Counselor. Please proceed.
So the respondents would have you believe that they can basically put up a wall of silence and they don't have to give any reason for not selecting the candidate.
But isn't that correct? Isn't there a case law that specifically says that they don't have to give reasons?
Well, according to Matter of Fish, they do have to give reasons when the candidate's overwhelming.
But are there other cases that since Matter of Fish, have taken a contrary position?
Presumptions are not, they're not favored in legalese. I mean, this has created an irrebuttable presumption where it's presumed that the respondents have acted with a rational basis, and basically there's no way to rebut that presumption. There's a complete, there's no way for an applicant who knows that they were overwhelmingly qualified, who dedicated a decade of their life to, 2 degrees in criminal justice with perfect grades, working for the governor. I mean, he has an exemplary record. And for him to dedicate that decade of his life to becoming a police officer and then just be given a 1-page paper unsigned by anybody with no valid basis whatsoever, I mean, it creates this irrebuttable presumption that that is clearly violative of Article 78, which is supposed to be...
it's speculative, I think, but couldn't it be there are 3 candidates? And the NYPD, for whatever reason, believed that they picked another candidate. Isn't that sufficient? Even though your guy, I'm sure, was well qualified.
Again, it's possible that that's the case, but then the reason why it still does not give them unfettered discretion. The discretion is not without limits, like you said. I mean, it's not relying on. They're just basically. Article 78 is used to review a decision of an officer or a body. And here we are with the respondents basically saying that they could have no valid basis whatsoever, and it could be unlawful, it could be illegal, but they don't have to provide that basis, and therefore it's impossible to challenge it in an Article 78, which is in violation of the spirit and letter of the law.
Thank you, Counselor. Thank you both. Next up, 47 East 34th Street versus Bridge Street. You may proceed, Counselor.
Good afternoon. May it please the court. David Daniels for Defendant Versa. I will be addressing mere continuation as to Versa and alter ego. Mr. Gelber will be addressing mere continuation as to Domus funding and fraudulent transfer. Now, Versa is a private equity fund advisor. It advises and manages companies owned by its managed funds, but does not own those companies or They're assets.
Well, sort of the issue we're grappling with here is how do we consider the request for admissions?
Well, Your Honor, the requests for admissions pertain to Domus funding, and Mr. Gubber will address those. But if you look at the request for admission, request admission number 14 says that Bridge Street wasn't owned by Versa Capital. It was owned by the fund that Versa Capital manages. That's in that request for admission itself. So the request for admissions don't pertain to Versa.
No, it is my understanding that the court, in its November 2019 decision, determined based on those admissions in the notice to admit that Domus funding owned 100% of Bridge Street and that Versa controlled Domus. So against that backdrop, what I'm interested in understanding is that was a 2018 admission. Nothing was done about it till well after the 2019 order was issued and notice of appeal was filed, but it was never perfected. And the court made a finding in that order that the plaintiff met its prima facie burden based on the admissions to suggest that there was mere continuation. And then perhaps the court wanted to tie up loose ends, I guess, in the context of satisfying all the Schumacher factors. So it's against that backdrop that I'm interested in you answering the question of how, at this late stage, can you come and say the court abused its discretion in not allowing you to amend those admissions in a notice to admit several years earlier?
Well, yes. Well, Your Honor, first of all, the evidence is crystal clear that my client certainly did not acquire any assets in that foreclosure transaction. That's uncontested, and we've taken that position since the outset of that lawsuit. In fact, the plaintiff concedes in her answering brief that Versa Capital did not receive those assets. Now, Domus funding, Mr. Gelber again will address the admission as to Domus funding, but the important thing for this court to realize is that Versa Capital and Domus funding are two distinct entities. The trial court blurred that distinction because it adopted the phraseology of the Versa parties.
Well, but arguably, you folks created it by responding in a way. Maybe there was ambiguity, but it seems to me that maybe it wasn't you, it was your predecessor. That's the problem. So, but going back to Judge Schulman's question, did the trial court, in its first summary judgment motion, did it make factual findings with respect to the issues we're discussing?
Well, they made prima facie findings with respect to summary judgment based on the papers that plaintiff submitted. But if you look at those prima facie findings at record 522, they say quite clearly, and let me quote, that, quote, Domus acquired the goodwill and other assets of Bridge Street, and that, quote, it was the intent of Domus to continue the operations of Worldwide. That's what the trial court found as a prima facie finding. Now, that doesn't bind...
Well, is it a factual finding? You say that was a factual finding made by the court?
No, Your Honor. That was a prima facie finding of the plaintiff's entitlement to summary judgment back in 2019.
But on the other hand, then summary judgment was denied. So how is that a prima facie finding if summary judgment is denied?
Summary judgment was denied because we introduced evidence at the time indicating that there wasn't a mere continuation of these businesses. And in fact, the evidence that was submitted at the time showed that Versa didn't even own the party that the plaintiff alleges is the purchaser. And that, again, has been the consistent position throughout this case. So if you look at the requests for admission at record 1324, paragraph 15, it says that Domus, that the Bridge Street entity is owned ultimately by the fund that Versa manages, not by Versa. If you look at the worker answer, again, another supposed admission that the plaintiff relies on, record 1310 and 1312, says that Domus and Bridge Street are owned by the funds advised by Versa. Now, there's some confusion here because of the fact that the fund and the advisor bear the same name, Versa Capital, Versa Fund, but they're two completely different entities. They don't share a common ownership structure. They stand in completely different branches of this corporate tree. The fund advisor is merely a manager, and it doesn't have that ownership interest, it doesn't have that ownership position. And that was the central confusion that the trial court missed when it was granting summary judgment the second time around. Now, with respect to the plaintiff's theory as to control, it says that control is sufficient, but there's no authority for that position. Now, mere continuation is an exception to the general rule that a successor is not liable for the debts of its predecessor, and liability follows the assets of the acquiring entity. So there is no exception for control. Now, very briefly, for alter ego, Your Honor, there's no evidence that BWW was rendered insolvent by Versa, and given that, the ultramar rule is controlling. And ultramar says that a secured lender has a duty, has no duty, to leave collateral behind as reserve for the debtor's other creditors. It's controlling precedent from this court, not addressed by the plaintiff. Without evidence that we rendered BWW insolvent, that rule is clear, and there is no such evidence. The evidence shows that we put money into that company. We didn't take money out. The evidence also shows that at all times, this company was worth less than what it owed on its secured debt. Plaintiff has submitted no evidence whatsoever that the value at any point in time exceeded the amount of secured debt. We've submitted an appraisal, we've submitted lay opinion testimony, we've submitted a transaction of the loan sale itself, whose only value is the collateral. All that confirms that the value was less. And that means that there's no harm, there's no injury, and there's no purposeful intent to cause an injury on a claim that wasn't even known.
We can't draw the inference, at least to create an issue of triable fact on alter ego liability just from the nature of the transaction, that it left parties like the plaintiff out in the cold and unable to collect it all.
Well, Your Honor, with respect to that claim or that argument, the correct party has been in plain sight if they want a remedy for this kind of transaction. The correct party has been Domus Group, the entity that actually carried on the business and acquired the assets. The fact that they chose deliberately not to add Domus Group, it doesn't mean that this court should reject precedent, disregard its precedents, in order to fashion a remedy against a separate entity just because the plaintiff is looking for a deep pocket.
Thank you, Counselor.
May it please the court, Zach Gelber on behalf of Domus Funding. Where a company acquires the assets of another company, the acquirer is not liable for claims against the seller. The mere continuation doctrine is a very limited exception to this that says where—
Counsel, can you deal with the question about the 2019 ruling and why you didn't jump up and down and say, no, we didn't mean the admission the way you interpreting that we meant the admission, Judge?
Well, so
why weren't steps taken? We're here, it's much later that you moved to amend your answers to the notice to admit.
Well, let's look at the notice to admit and then the timeline. So the notice to admit says that Domus directly or indirectly owns the equity interest in Bridge Street, not BWW, and it doesn't speak to the factors that are involved in successor liability. So in order to fit in the limited exception for being a mere continuation, you have to take on all of the assets, continue all of the operations. So the notice to admit should have been amended, but even if it wasn't, it doesn't go nearly far enough it doesn't come near proving what the plaintiffs needed to prove in order to meet their burden on mere continuation. The undisputed facts of the transaction are that Domus Funding did not assume any of the assets or any of the liabilities of BWW. And in fact, in the 5,000-plus page record, there's no evidence indicating that the transaction shows them having done that. The reality is that 47 East named the wrong party. Now, if we were here today talking about whether Domus Group was the mere successor or the mere continuation of BWW, that would be an interesting question. But we're not here answering that question today. And the reason is because plaintiff was aware that Domus Group was the party in interest that had assumed the assets, but they didn't name them. And so if we look at the timeline now on the notices to admit, so at the beginning of the case, October 2018, 2 months after the case is filed, the Versa and Domus Funding produced the ATA and CTA, the key transaction documents. And in fact, it's very clear that plaintiff understood these documents because in their first summary judgment motion, which they filed in July 19, they state it was Domus Group that emerged from the foreclosure holding all of BWW's domestic assets. So the notion that somehow there was prejudice or they didn't understand who the true owner was is simply not true. The first time that they stated on the record that, or cited to the notice to admit on the record was in March of 2020, and it was soon thereafter.
So are you saying that on the initial go-around, Supreme Court didn't rely on the notices to admit in fashioning the determination that was made?
There is no explicit reference to the notice to admit in the 2019 decision.
And what's your view? Did Supreme Court make factual determinations that are either law of the case or something, given the posture of the case, dismissal of appeal, that we should consider?
Well, its determinations are certainly not the law of the case. What the Supreme Court determined in 2019 was that based on the facts before it, that it made a prima facie finding that the plaintiff had made out a case that Domus Funding had absorbed BWW. But as I mentioned, this is simply not sufficient to make out their case. Even the court itself said there were other facts that still needed to be proven. So at best, in the second go-around on summary judgment, they would still have to come forward with evidence, and there was still clearly an opportunity, or there should have been an opportunity on behalf of Domus Funding to rebut that evidence.
So in other words, you believe that we should just look at the second order and the evidence around the second order and to determine whether or not Supreme Court was correct?
Absolutely. There's no question that the trial court erred in not looking at any of the transactional documents and relying simply on a notice to admit that everyone knows is erroneous. And there's no question that if you look at the transaction documents, the notice to admit is not correct. It doesn't prove what it needs to prove. And the argument with the law of the case, certainly the summary judgment decision isn't the determinations that were made are not the law of the case, and it was not a sufficient basis on which the court completely disregarded the evidence of the transaction and what had really happened here.
Now, similar admissions were made also in Delaware, is that correct?
There were certain admissions that were made in Delaware that were corrected.
What occurred there?
In Delaware, there was, I'm not sure if it's part of the record, the Delaware admissions.
But they were fixed.
There were admissions made with respect to ownership that were corrected.
Okay.
And so if I may shift to fraudulent transfer, we believe for the same reasons that the court clearly erred in that the assets did not go, and I think I can't overemphasize this, the assets did not go to Domus Funding. It is not the inheritor of the business or the continuation of the operations. For the same reason, there can't be a fraudulent transfer because it's not the recipient of any assets. And so that in and of itself is dispositive.
And how did you show that in the record?
Well, the transactional documents, the CTA and the ATA, both make clear that all the assets went, the foreign assets went to, foreclosure was done by Domus UK, the foreign entity, and the domestic assets went immediately to Domus Group. There's other evidence in the form of...
So plaintiff was aware of Domus Group through the transactional documents, but chose not to sue Group.
Correct. And in fact, we offered every opportunity to plaintiff to add Domus Group, and they chose tactically, for whatever reason, not to add them. The case was going well. They thought they had a path to victory, and so they chose not to add them. And they shouldn't be heard now to come forward years later and say, wait a second, we don't have the right parties here, or we have to hold this other party liable because we don't have Domus Group, because they well knew that Domus Group was involved. And we don't have to look any further than their own summary judgment papers in 2019 to see that. There's two other reasons that fraudulent transfer should have been granted to Domus Funding. First, there's no evidence of any, beyond the fact that none of the assets were received by Domus Funding, there's no evidence of malintent, and all we have to do is look at the timeline. The timeline is clear. The foreclosure took place in March of 2014. The claim, even against Bridge Street and BWW, didn't ripen until the summer of 2014, and Domus Funding and Versa weren't sued for another 4 years. So the notion that somehow we had the intent to defraud 47 East just makes no sense at all. There's no badges of fraud. There's no other evidence either. Finally, there's also evidence of fair consideration. A secured lender is entitled to accept as fair consideration for a secured loan the foreclosure of the assets. And all the evidence in the record points to the assets having been reasonable consideration, and plaintiff has put forward no evidence to the contrary. Thank you.
Thank you, Counselor.
Good afternoon, Your Honors. Ellen Werther from Wrestler and Wrestler on behalf of Respondent. I feel like I'm Alice in Wonderland looking through the looking glass. I've been involved in this case since 2017. And the admissions that were made to Justice Barak were consistent from the time I first appeared in the case until the time they fired their lawyers after they lost the 2019 decision. The gentlemen you see here are the new replacement counsel. They not only had the admissions that were given to Justice Barak.
I understand you're relying on the admissions. Your adversaries contend, or one of them contends, that you got the wrong party here. It was clear from the transaction documents that it should have been Domus Group instead, and that you made a tactical decision not to sue them. What about that?
It's untrue. When they produced the documents to us in the beginning, they gave us something called a closing binder, which is part of the record on appeal. The closing binder was the Versa Capital closing binder. Inside were all kinds of what they denominated as internal Versa transactions. Those documents indicate on their face that what happened was, under the CTA, all of the equity in all of BW's operating entities was transferred to Domus. And
Which Domus?
There's only one Domus. Domus Funding LLC. Domus BWW Funding LLC. That's a special purpose entity.
So it's your position that there's nothing in the documents to suggest that it was really Domus Group that acquired BWW's assets?
Let me get to the next point. It then shows that what Domus Funding LLC did was it then assigned the equity to different Domus affiliates, all owned and controlled by Versa, as that suited its interest. The evidence before Justice Barak shows that, in fact, the certificates membership, LLC membership interests were tendered in blank. They were signed by Mr. Dembiak on behalf of BWW, tendered to Versa Capital in blank, and Versa Capital then distributed it among a network of Versa wholly owned affiliates. If they didn't wholly own them, there's a network of interlocking LLC agreements that give Versa Capital unfettered control over all of the network of LLCs. In fact, all of those LLCs have now no more money in them. So no wonder they want me to go after Domus Group. That was always the posture. Go after this shell company that no longer has any money and leave us alone. But you have to look past the facade. In fact, what happened was they controlled every element of it. They controlled all of the cash. They upstreamed all of the cash. And when I went to enforce a judgment against Bridge Street, which was affirmed by this court on appeal, and the Court of Appeals declined leave to appeal, I went to enforce it. They changed the name and they filed a Chapter 7 petition or Chapter 11 petition in Virginia. So then I go back to Justice Barak, say, guess what? I'm back. And he said, I'm going to direct you to now move for summary judgment. Why? Because it's clear to me, as the evidence and the record has developed, that you in fact are correct, that Versa Capital owns and controls everything, and Domus is one of the affiliates through which it does that.
Now, the evidence that you refer to, is it just the admissions?
No.
Or is it your position that it's admissions plus the record?
It's admissions plus, because after the 2019 decision, Justice Barak said, okay, get more discovery, which we did. And in fact, he directed Versa Capital to turn over all of its internal records, which they had previously withheld. Lo and behold, what do we find? Number one, we find the bring down memo, which is Versa Capital's own rendition 4 days after the transaction of what happened. It talks about Versa Capital obtaining ownership. It talks about the identical employees going from BWW to Versa Capital. It talks about the identical locations, the identical management. It also talks about value. And it talks about, well, we originally offered to buy the company in an all-stock transaction, but we decided to do an alternative transaction that cost us less money through a planned foreclosure. This is all orchestrated. This is not by happenstance. So they go out and they buy the Credit Suisse debt in I think it's late April, early May of 2013. Now, that Credit Suisse debt was not ordinary debt. It carried with it the right to appoint members of the board of directors. So what happens? They buy the debt, and being clever, they immediately enter into what they call a memorandum of understanding with the two key senior executives of the company. Cutting to the chase, it says, we'll pay you extra if there is a sale to us in a consensual foreclosure. That's in the spring of 2013. In September of 2013, they enter into this they negotiate a forbearance agreement with those key executives who are the key beneficiaries of that agreement. The forbearance agreement says, oh, this is what we're going to do. You're going to perfect the previously unperfected security interests. They did not have, it wasn't completely perfected. Those were not certificated LLC membership interests. That's a whole arcane area. But basically, if you have certificated membership interests, they can be perfected by possession, as opposed to uncertificated. You have to change your LLC agreements. You have to change your management. You have to put new members on the board designated by us. They didn't have to exercise their pledge agreement for stock to do that. The Credit Suisse agreement gave it to them. And in addition, there were hair trigger covenant operating defaults. It wasn't just if you don't pay us, you're in default. It says if your EBITDA goes this much down, if your revenues go this much down, if your occupancy rates go this much, like from 95 to 94, we can call a default anytime. And in any event, there's a hard break date, no matter how you perform. So it's signed. And and at that time, I must mention, there is no valuation given to anybody. They have now come in with this, quote, independent valuation. Look at the date. The date is the end of January 2014. That is all as it seems. And that valuation shows that and it was never presented to anybody during the time of the foreclosure agreement, forbearance agreement, because it hadn't even been done. It shows that Versa layered on, took the debt from 30 million, took it up to 45 million. And most of the money that was layered on was circled back to whom? To Versa and its affiliates in the form of just straight payment, extra fees, all kinds of nice things.
So for the bottom line then is, from your point of view, there was an admission in 2019 that Domus Funding took over Bridge Street, and Versa controls Domus Funding.
Absolutely. If you look at...
And
yes.
just bear with me for a second.
I'm so sorry,
I
yes,
just want to
sir.
get your position. So, and therefore, when Justice Barak in 2019 determined that you met your burden
Yes.
in opposing their motion to dismiss under 3211, he said you met your burden not only to defeat that motion, but in terms of a part of your summary judgment motion, your cross motion, correct?
Yes, Your Honor, but also it was with respect to personal jurisdiction. They moved to dismiss for want of jurisdiction.
Fair enough. So from your point of view, how do you reconcile, as my learned colleague asked your friend over there, how do you reconcile a court finding that you met your prima facie burden initially, and then at the same time denying you summary judgment and requiring, as you pointed out, further discovery to develop the other Schumacher factors that you believe you developed to win it on the second round?
Because he identified two and only two factual issues, which actually were easy enough to prove once I got the documents. One was the number of employees, it was the same before and after. I got the documents prepared by Versa Capital's employee compensation carrier. and I showing exactly 450 employees before and the identical ones after. And I got the schedules to their 2014 credit agreement, which showed the location before and after exactly the same. I also think that what put Judge Barak over the top was when he got a consent, after everyone tells him, oh no, there's no overlapping management, signed by Mr. Kennedy. It was very interesting. He signed the notices to admit. He was the general counsel of Versa. He was an officer of Bridge Street, and he was an officer of Domus Funding LLC. He signed the same consent, and it was a consent to what? To let Bridge Street's lawyer withdraw from the case with no representation after we had obtained a judgment and we were chasing them to recover it. And I might note, Your Honors, every time we get a judgment against them or a decision against them in any court, including this court, and they don't like it, they run to another court, change the name of the entity. If it's a judgment, money judgment I've gotten, they strip the assets out, and they say, oops, here we are. Your Honor, it has to come to an end. What we urge the court to do is to search the record and to affirm Justice Barak, who lived with this case for years. When they tried to take it to the district court, Southern District Court said, Judge Barak is the one who really knows the record in this complex case. He's the one who knows. We'd like you to affirm and enter judgment against Versa Capital and Domus in favor of 47 East.
Thank you,
Enough is
Counselor.
enough. Thank you, Your Honors. I have so much more to say.
Your Honor, with respect to plaintiff's suggestion that the defendants have been playing games with respect to corporate formalities, it's not true. We paid very careful attention to corporate formalities. The plaintiff here has been trying to gain an unwarranted preference over other BWW creditors and transform an unsecured claim into some kind of priority over a secured claim. That's simply not contemplated in any law. Now, with respect to the admission that Ms. Werther just made in the argument, she said that the assets were transferred to Domus Funding. Under the Schumacher standards, that's the end of the story as to Versa Capital, because Schumacher quite clearly says that the mere continuation doctrine applies to the purchaser. And plainly, Versa Capital was not the purchaser, regardless of what the court thinks as to Domus
But is it
Funding.
so clear that the parties are separated? Because your adversary certainly says that the record does not bear what you're saying to be correct.
Well, yes, Your Honor, they were quite separate. They maintained corporate formality. And if you look at the affidavit of Mr. Kennedy at 3579 in the record, he explains the difference between the corporate formalities between Versa and the purchaser. Formed for different purposes, they had different businesses, maintained separate finances, and all that evidence is uncontested. So the separation is important, and control is not sufficient. Ownership is not sufficient under the Court of Appeals precedent in Schumacher. Now, very briefly as well, at the end of the day, this case, it raises a real question mark over something that the UCC drafters really wanted to promote, which was consensual foreclosures. The whole idea about a consensual foreclosure is that it produces a better outcome for everybody. And it's the expectation of the secured lending industry and private equity in the state that they would have availability of those kinds of remedies. But if you adopt plaintiff's theory and hold the private equity manager of a secured lender liable on these facts, no sensible lender will ever use this remedy again. Thank you.
Thank you, Counselor.
Respondent's argument is full of vague allegations, but the actual facts in the record are clear. If we look at the transaction documents, there's simply no question that Domus Funding did not receive the assets or take on the business of BWW. And you won't hear Respondent's counsel say anything to the contrary because they haven't and they can't.
If those admissions are binding on you, can you still get summary judgment?
The admissions don't, can we be granted summary judgment? Yes, because under the mere continuation is a very limited exception. It only occurs where we have a company which is effectively taking on all the operations of another company, right? The general rule is we want parties to be able to purchase assets without unknown liabilities creeping up on them, right? So it's only in a rare circumstance in which a company buys all the assets and takes over all the operations such that we'd say they're actually the continuation of that business that doctrine prevails and the liability runs with those assets and operations. Here, they haven't met any of that standard. It's clear, regardless of whether they can rely on an erroneous notice to admit, which says that Domus indirectly or directly owns Bridge Street, it still doesn't get them anywhere near where they need to be to prove mere continuation.
Right, but they wouldn't have to prove mere continuation to forestall summary judgment in your favor. So with the admissions, if they are binding, they would be some evidence, right, at least as to certain aspects of Schumacher that are favorable to the plaintiff.
Well, ownership is certainly not enough. If they can't make out that the business has continued under the same owner or that the assets were transferred to the same owner, then they can't meet the standard, even if they meet one of those three parts.
What about counsel's statement that we have an identity of employees and identity of location? Those are additional Schumacher factors that Justice Barak relied on in his later order to grant summary judgment?
Counsel, I believe, is paying fast and loose with the language, as the court did, of who the employees worked for. So Bridge Street's employees and operations stayed the same, but BWW, which was assumed by Domus Group, none of those stayed the same. And certainly, they weren't the same with Domus Funding, because Domus Funding was no longer in the picture. Domus Funding was gone long ago. So what respondent is trying to get you to do is to ignore the reality of the transaction and the corporate form, which matters. Thank you, Your Honors.
Thank you, folks. Very good argument. Thank you. Okay, the final case is Surefire Dividend versus Industrial and Commercial Bank.
Good afternoon, Your Honor. Glenn Lenahan with Ovid and Ovid LLP for Appellant. This action arises out of Appellate's investment in Broadreach Capital Limited Partnership, a hedge fund in which Appellant invested. The respondent acted as a clearinghouse for Broadreach. The lower court appropriately and correctly upheld Appellant's claims for aiding and abetting fraud and aiding and abetting breach of fiduciary duty. However, the lower court erred when it dismissed certain portions of those tort claims by holding that they were not assigned to the appellant from a prior limited partner in Broadreach Capital Limited Partnership.
Counsel, how do you reconcile the fact that while you're arguing that the in-kind subscription agreement assigned to your client, Surefire, the legal rights of the A fund, correct? That's your position. The court erred in denying you right to have standing on that basis.
Correct, yes.
How do you reconcile that with the court's, same court decision this past April, where it denied the motion to dismiss A fund's direct claim, under the same legal rights you claim you bought?
Right,
So in a sense, how do you reconcile that?
Because in that universe, the court, Justice Ostrager, made his decision that the claims were not transferred from the A's funds to the appellant here. In that world, based on that decision, the A funds still own those claims. So there, in that set of facts, assuming that is a given, the A funds still own those claims and they can bring those fraud, aiding and abetting fraud, and aiding and abetting breach of fiduciary duty claims. But the issue here on this appeal is that we believe that the lower court incorrectly made that finding.
Okay, so fair enough. So what's the language in the subscription agreement which evinces an intent to transfer the fraud-based claims?
Sure. So it reads specifically, the A funds, the entities we define as the A funds, hereby transfers the full balance of its interest in Broadreach Capital Limited Partners to appellant. There, you're not transferring only a contractual right. All of the cases the case that the lower court relied on and the cases cited by respondents all involve either a note or a security, such as their residential mortgage-backed securities, or a contract. We're not dealing with rights under a contract. They are stepping into the shoes of the limited partners. If this subscription agreement said we transfer our interests under the subscription documents, I would agree with the lower court, but that's not what it says here. And this is backed up by the Second Circuit Court of Appeals finding in Bank Arabe v. Maryland National Bank, where the Court of Appeals found, the Second Circuit Court of Appeals, held that a recitation and assignment agreement that transferred all of
But
the
let me stop you there,
predecessors-
Counselor. Let me stop you there. If you read the entire 5 lines, it ends with saying balance as determined by Broad Capital LP's administrator, Nottingham. That really suggests to me what we're talking about is a money transfer.
Your Honor, respectfully, I disagree, because what that says is this transfer is made for the purposes of facilitating an in-kind subscription to the fund in the amount of its balances of a certain date. When the appellants themselves became limited partner, when anybody becomes a limited partner in such a fund, you have to give consideration. You don't just get a limited partnership interest without paying something. So what this is saying is the A funds are going to give up their status of limited partners. You're going to stand in my shoes as limited partners, and the amount that you're going to have, the amount of your limited partnership, the percentage of that in the fund is going to be based on the amount as of the balance as of February 28th, 2019. This is not limiting it at all, only to a financial interest whatsoever. And that's supported by the allegations in the complaint, which expressly say that they negotiated this to transfer all legal rights, including contract, including tort, including fraud, that did exist or could exist. On a motion to dismiss, a pre-answer motion to dismiss with no discovery, we believe that this is that the court erred, and that's demonstrated where it cited to Commonwealth of Pennsylvania against Morgan Stanley, which was a summary judgment case where there was no written assignment agreement, and the court held that the plaintiff failed to come forward with any evidence that the parties intended to transfer anything other than contractual rights. And this is further supported by the fact that the respondents cite to only 2 cases where this type of decision was made on a pre-answer motion to dismiss. Both involved RMBS, giving rights in RMBS, residential mortgage-backed securities, not in a limited partnership. And in fact, the First Department in Dexia cited to the Second Circuit Court of Appeals decision in Bank Arabe, where they found that a transfer of all rights in a described transaction included the transfer of rights to a fraud claim, which the Court of Appeals cited to approvingly in Commonwealth of Pennsylvania.
Thank you, Counselor.
Thank you.
You may proceed.
Good afternoon. Elizabeth Curran from Schulte, Roth & Zabel on behalf of Respondent, Industrial and Commercial Bank of China Financial Services LLC, and may it please the Court. The Supreme Court here correctly determined that Appellant Surefire was not assigned fraud claims by its predecessor, the A funds, and thus does not have standing.
So what does it mean, a balance of its interest? Does that include fraud, all the fraud claims?
No, our position, Your Honor, and the position of the lower court is that that does not include fraud claims.
And why is that?
I think you have to read the agreement as a whole, as I think you just discussed with counsel for appellant. The agreement clearly says that it transfers the full balance of its interest. Balance is interpreted as the difference between a credit and a debit in an account per Black's Law Dictionary. It goes on to say that the transfer is made for the purpose of facilitating an in-kind subscription in the amount of its February 28th, 2019 balance. Words like balance, amount, those are financial terms, and they don't refer to fraud claims. It's very clear that this agreement only refers to the financial interests. And as the Supreme Court correctly recognized, the agreement is unambiguous and plainly demonstrates absolutely no intent to assign any legal claims to Surefire. Under New York law, for an assignment to be valid, there has to be at least some language that demonstrates this intent.
So that's the Commonwealth case. Your adversary distinguishes it, saying that that was a summary judgment motion, this is an A7 motion, we should get some discovery, et cetera. And then maybe we could make that determination. What's your response?
So, yes, Commonwealth of Pennsylvania was a summary judgment case, but there are other New York courts that have determined that the reasoning from that case applies at the motion to dismiss stage. Counselor's attempt to distinguish those cases has no merit because simply saying that they deal with mortgage-backed securities as opposed to a financial balance is not a practical difference. There's no justification for why those cases are inapplicable here other than the fact that that seems to suit their argument. Their argument is that this transfers more than the financial balance, but that's not what the contract says. There is no difference between transferring mortgage-backed securities and financial interest, and those cases that apply Commonwealth at the motion to dismiss stage are applicable here.
Counsel, do you believe that A Fund's lawsuit, which was commenced after the earlier decision was issued by the court below, somehow moots this appeal?
I think that Justice Ostrager correctly determined that these claims were not transferred to Surefire and that the A funds, are still the holder of the claim. Whether their claims in that lawsuit have merit is yet to be determined by the lower court. Let's see.
Does Surefire still have the claim, Surefire still has its own claim for its own fund that it invested in, and of which they're holding your client liable as a broker?
That's
or
right.
a clearinghouse.
Surefire invested independently, and that claim is still live. But by virtue of holding that this in-kind subscription agreement is unambiguous, it's clear in its face, it only transferred the financial interest. Surefire is not the holder of those fraud claims, and we respectfully ask that you affirm the lower court's decision.
Thank you, Counselor.
Your Honors, there's a lot of gymnastics going on with the language of what actually is in the subscription agreement, and this is demonstrated by the fact
respectfully, I disagree. I mean, we're just reading the words the way they're written. Balance of its interest. What does balance of its interest mean? To an ordinary person, it seems to be referring to monies.
I respectfully, I disagree, Your Honor, and their citation of Black's Law Dictionary's definition of balance shows that, because that's the definition when balance is a verb. And the example they give is the accountant balanced the company's books. Balance here is not a verb. This is saying whatever they have, because your interest will change over time when you're a limited partner, depending on whether the limited partner shares are given out to anyone else. So they have to look at a specific place and point in time. Here they chose February 28th, 2019 to determine what percentage interest as limited partners they would have in Broadreach. This was transferring all of their interests as limited partners. And like in Bank Aribier, which was cited
Well, isn't that how they should have said it if that's what they meant?
Your Honor, there's, in hindsight,
balance to me seems to be a more circumspect, more cabined word than interests.
Well, it does say interest. It says the full balance of its interest in Broadreach Capital LP. It doesn't say its interest.
But on the other hand, and I am sorry to interrupt, at Commonwealth, it wasn't sufficient to say all rights, title, and interest.
But that was in a note. That was in a note, just like an RMBS or a contract. This is not what we're talking about. And as I said, if this says full balance of its interest in the subscription documents, that would be a very different case, but that's not what it says. It says full balance of its interest in Broadreach Capital Limited Partnership, and its interest in the limited partnership with its status as an LP. And as an LP, you have rights to sue. A note, an RMBS has never defrauded anyone. A person or an entity defrauds someone. A person can't be defrauded by a piece of paper. That's why those cases are distinguishable here, because this doesn't involve an interest in the subscription documents. It involves their status as limited partners.
Thank you, Counselor. Thank you both.
Thank you.